Hi, I'm Anthony Diosdi. I'm a tax attorney in San Francisco with over 20 years experience in international and domestic tax planning and tax litigation. You can find me at sftaxcounsel.com. Hi, today we're going to be talking about establishing and breaking U.S. residency for tax purposes. So, when you are a U.S. resident for tax purposes, what that means is that you're taxed on your worldwide income. You are taxed not only here on income from U.S. sources, but you're taxed on income that you earn from outside the United States. How does one become a U.S. resident for tax purposes? Well, the first one's the easiest. If you are a citizen of the United States, then you're taxed on your worldwide income. Second, if you are given a green card, if you're a naturalized resident of the United States, a green card holder is also taxed on worldwide income. Now, there's an exception to this rule, and we'll get into that in a little bit. But as a general rule, if you are a green card holder, you are taxed on your worldwide income. And then the third way to be taxed on your worldwide income is if you're not a resident, but you are in the country long enough, you're in the United States long enough to pass what's called the substantial presence test. And if you pass the substantial presence test, which we'll talk about in a minute, you are also taxed on your worldwide income. And then the fourth and lesser well-known way of becoming a U.S. resident for tax purposes, if you make an election, you can make an election. If you're not a citizen or resident of the United States, you can make an election to be treated as a tax resident of the United States. Okay, so let's talk about how somebody satisfies the substantial presence test and could be classified as a U.S. resident for tax purposes and taxed on worldwide income. So this is an individual who is not a citizen, who is not awarded a green card, but yet is in the United States for at least 31 days in a given year. They're in the United States for 183 days, in addition to being in the United States for more than 31 days. And that 183 days, there's a look back period for the last 2 years. So the first year, the year that the measuring takes place, you would count one full day. The previous year, you would count 1/3 of the days. And the year before then, 2 years before the measuring year, you'd count 1/6 of the days. So if you take into consideration all 3 years, including the present year, and that amounts to 183 days, then that person becomes a U.S. resident under the so-called substantial presence test. That means that that individual is taxed under worldwide income, and they're responsible for all the reporting requirements that come with it. Now, there's an exception to this rule, and the exception to this rule is if this individual who passes the substantial presence test has a closer connection to a foreign country. So if this individual has a tax home that's not in the United States and has a closer connection to that other country, then it is possible to break U.S. residency for tax purposes under the substantial presence test. And how do you establish a tax home in a foreign country? Well, let's just say the individual's family, their spouse, their children, their extended family is in a country outside the United States. Let's just say they have a large home outside the United States. Let's just say they're professionals, they're doctors, they're dentists, they're automobiles. That's all outside the United States. That's in this other country. That individual has a closer connection or a tax home outside the United States, even if that person satisfies the substantial presence test, meaning that they've been in the United States for 183 days or longer, then it is possible to break that residence for U.S. tax purposes. Now, there's one exception to that rule, and that one exception to that rule is if that individual has begun the process to become a naturalized resident of the United States or a naturalized citizen. They've already went ahead and they filed the appropriate documentation with the United States government. They've taken steps to become a permanent resident of the United States. In that case, even if you have a closer connection to a country outside the United States, you can't use the exception to this rule. It's not going to work on. Now, if this individual has not started the process to become a naturalized resident of the United States, and they, for whatever reason, have been in the United States for that 183 days or more, and they want to go ahead and claim that they have a closer connection to another country, a tax home in another country, there is filing requirements with the Internal Revenue Service. You can't just go ahead and say, well, I have a closer connection or I have a tax home in another country and not file a tax return with the Internal Revenue Service. What that person will need to do is file a Form 1040-NR with the IRS and attach to that Form 1040-NR a Form 8840. And that Form 8840 has a number of different questions on there. Particularly, it goes over where that person's closer connections are, where that person's professionals are located, where that person's automobiles are, where that person's driver's licenses are, where that person's home is. That's going to be on that Form 8840. It's a fairly lengthy form, and there's also room for an attachment to kind of go ahead and describe that individual's facts and circumstances. So hopefully they can go ahead and break residency with the United States for purposes of breaking a substantial presence test. So if you're an individual that's been in the United States for 183 days or longer during that testing period, which I discussed earlier, and if you want to break U.S. residence for tax purposes, it is important to go ahead and file a Form 1040-NR, the tax return, that proper return, and attach that Form 8840 to the tax return. Now, let's just say you have an individual who is a green card holder, and let's just say they're taxed on a worldwide income. Is there a way to avoid taxation on the worldwide income? And the answer is yes. In certain circumstances, if that individual is a person who has a connection, let's say a person's a resident of a country that the United States has a tax treaty with, in certain cases, it may be possible to take a so-called treaty position. And that treaty position itself would wind up, in some cases, breaking the U.S. residency for tax purposes. So if an individual, and this only applies to green card holders, by the way. This does not apply to U.S. citizens. A U.S. citizen, it is very rare, unfortunately, that they could actually benefit from a U.S. tax treaty for purposes of helping them with their U.S. tax liability. U.S. tax treaties itself, unfortunately, the way they're drafted, it doesn't do a heck of a whole lot of good for U.S. citizens. But if you are a green card holder and you spent the majority of the year in a country that the U.S. has a tax treaty with, it is possible to take a position that you have a closer connection to that other country. And if you have a closer connection to that other country under the treaty, the importance of this is that you can be taxed as a non-resident for U.S. tax purposes, meaning that you'd be taxed on your U.S. source income. So any income that you earned in the United States would still be taxed. However, if you could take a treaty position, a so-called closer connection treaty position or a residency treaty position, with a country that the U.S. has a treaty with, then it is possible to avoid taxation on your worldwide income. Unfortunately, unlike if you were able to take a position under the substantial presence test and break your residency that way, you would still have an obligation to file a number of information returns, such as a Form 471, if you have an interest in a foreign corporation. If you take a treaty position, ordinarily necessarily absolve all your filing requirements for your foreign activities, but for the most part, it will result in you not having an income tax consequence on your foreign source income. How do we go ahead and determine if somebody could benefit from a treaty position? Well, the test itself is somewhat similar to that of using a tax home in another jurisdiction under the substantial presence test. It's typically if you have your family in that country or jurisdiction that you're trying to take a treaty position in. You have your home there. You have your automobiles there. You have driver's licenses there. You vote there. Let's just say, for example, your bank accounts are there. Your professionals are there. Your dentists are there. Your doctors are there. There's a whole slew of tests that take into consideration whether or not you have a closer connection to the United States or this foreign country that you're trying to take a treaty position with. It is important to take a look at the specific treaty itself that you are trying to utilize to break your residency with the United States. Every treaty is different. Every treaty is worded differently. And also, just because we have a treaty with a country that you're trying to go ahead and take a treaty position with and trying to argue that you have a closer connection with that other country, sometimes that treaty itself is not going to help you. A good example of this would be the United States treaty with China. The United States treaty with China, it just doesn't work for purposes of trying to take a treaty position for a residency based type of a claim, the way the treaty itself is drafted. But a number of other treaties, such as the US UK treaty, US Australia treaty, US Korean treaty, US Canada treaty. A lot of these treaties itself contain verbiage that if it's followed, then you could break your residency with the United States for tax purposes. This does not mean that you are giving up your green card or your residency in the United States. It merely means that you are taking a position under a treaty that you have a closer connection to a foreign country for tax purposes, and therefore you should be treated as a non-resident for tax purposes in the United States, and you should only be subject to income tax on your U.S. source income. Now, there's two words of caution if you're going to go ahead and take a treaty position. Number one, politics have kind of changed in this area. So if you are going to go ahead and take a treaty position, make sure that you are also consulting with an immigration attorney and you're consulting with a tax attorney at the same time to make sure that you're not running afoul to any U.S. immigration law and you're inadvertently terminating your U.S. residency by taking a treaty position. The other thing that you need to be very mindful of if you're taking a treaty position is the exit tax rules. If you are a long-term resident of the United States, meaning that you've had your green card for more than 8 years, if you go ahead and you take a treaty position and you're claiming a residency position in that you are trying to avoid tax on your worldwide income by taking a treaty position, what will wind up happening is that will trigger an automatic expatriation for U.S. purposes, meaning that you will be subject to the U.S. expatriation or exit tax. So be very, very mindful if you're going to take a treaty position that you are not classified as a long-term green card holder, because that could have catastrophic impacts on your U.S. tax consequences. However, if you have not been classified as a long-term green card holder, meaning that you have not held on to your green card for more than 8 years, it is possible to take the treaty position, meaning that you could avoid taxation on your worldwide income. That's number one. But number two, what you do by taking this treaty position is you are stopping that clock. You are stopping that 8-year clock from running. So in essence, what you can do is, let's just say you are working abroad for a company, and let's just say you are in the Emirates or you're working in Europe and you're concerned about hitting that long-term status of being a green card holder, and why some people don't want to have that long-term status of being a green card holder, because when they leave, they could be subject to the exit tax. By you taking a treaty position, you stop that clock. You stop that 8-year clock from running. It could also be used for tax planning purposes as well if you're concerned about the exit tax. I hope that you found this discussion to be helpful. If you have any questions about this topic, please feel free to contact me at my office. But as always, this discussion is not meant to establish a legal relationship with anybody. And it is not meant to be designed as legal advice. Thank you very much.